In 2016, a Supreme Court judge asked the state of Maharashtra, "Do you want to extract a pound of flesh?" What prompted the court to ask this? The question was directed against the state for contesting the bail plea of Delhi University professor G. N. Saibaba. Saibaba was arrested in 2014. The justification for this was to prevent him from committing what the police called anti-national activities. Saibaba, a 90% disabled man, was kept in solitary confinement. Less than a year after being granted bail by the Supreme Court, he was convicted to life imprisonment, along with 5 others by Maharashtra District Court, under the Unlawful Activities Prevention Act, for political beliefs and Maoist sympathies. This case revives questions around the UAPA, at the heart of which is what is a crime and who is a criminal. Journalist KK Shahina encountered the UAPA in 2009 when she was reporting on the Bengaluru blast case for Tehelka magazine in Coorg. While she was interviewing prosecution witnesses, the police showed up and told her to leave. Later that evening, she received a phone call from the local thana asking if she was a terrorist. A few days later, they charged her with intimidating a witness. When she tried to apply for anticipatory bail, they added provisions of the UAPA to the charge, under which getting bail is much harder. For Shahina, this was the beginning of a long and painful fight. The Unlawful Activities Prevention Act is a widely used and notorious national security legislation in India. The UAPA, like POTA and other security laws, is dangerously vague. For example, the term unlawful activity includes anything which causes or is intended to cause disaffection against India. So, you don't actually have to commit a crime to be booked under this law. You could be arrested for attending a protest meeting, or reading about the Chinese Revolution alone in your bedroom, or even not standing for the national anthem. The UAPA is categorized as a special law, which means it has some pretty sweeping powers. Many of its provisions violate rights and procedures guaranteed under the Constitution. For example, the police has the power to search, seize, and arrest without a warrant. There is a presumption of guilt in certain situations. The standard of evidence required to convict you falls, and bail is much harder to get. For people charged under this law, it means years navigating a bureaucratic, maze-like justice system. Even if they are acquitted, it becomes meaningless, because the process of reaching that point is itself like punishment. This is what happened in the case of Jyoti Babasaheb Chorge. In 2011, Jyoti was arrested under the UAPA. She was a 19-year-old student in Pune when she was picked up at a bus stop during a wave of arrests. To the police, the fact that she was friends with a number of people that they had already arrested was offense enough. The only charge that they could raise against her was being in possession of what they called Maoist literature. The judge wasn't impressed by this charge. At a bail hearing, Justice Thipse said that a person is not made a criminal by the beliefs that they hold. They actually have to commit a crime. He said that to arrest a person for possessing a certain kind of literature is a shocking proposition in a democratic country like ours. Jyoti spent a whole year in prison, but she was finally granted bail. Such legal victories are few and far between. Mostly, laws like the UAPA are used to threaten and persecute dissenters and minority communities. In 2008, 18 Muslim students were arrested under this law for having what the police called jihadi literature. In court, it was revealed that these books were just copies of the Quran. 6 years later, in 2015, all of the accused were finally acquitted by a trial court, and the so-called Hubli conspiracy case collapsed. This is not a one-off incident in the history of the law. In 2014, according to the government's own statistics, as many as 72.7% charged under this law were acquitted. That's 7 out of 10. That's a lot of people who spent time in jail for a crime they did not commit. In the same year, 4 juveniles were also apprehended under this law, and one of them was less than 12 years old. Should a law exist if its provisions are dangerously vague and its acquittal rate is so high? Critics of the UAPA say that it gives an understaffed and overworked police force the option of booking suspects under what's easiest for them, and that's usually what buys them more time for investigation. Under the UAPA, accused can be held for up to 180 days before even filing of a charge sheet against them. In his book Colors of the Cage, Arun Ferreira documents the kind of torture he experienced in police custody. My arms were tied to a window grill high above the ground, while two policemen stood on my outstretched thighs to keep me pinned to the floor. My ear started to bleed, and my jaws began to swell. In the evening, I was forced to squat on the floor with a black hood over my head as officers posed behind me for press photographs. And he says he got away relatively light. His co-accused had petrol injected into their rectum. Wahid Sheikh, a school teacher who was recently acquitted in the 2006 serial blasts case, said that in police custody he and his co-accused were waterboarded, electrocuted and gassed when they refused to sign confessions. He went on to spend 9 years fighting to prove his innocence. When he was finally acquitted, he told the Indian Express, "मैंने 9 साल में इस निज़ाम से faith खो दिया." Countless others who have been imprisoned under UAPA and other laws like it feel similarly abandoned and angry. Statistically, minorities tend to bear the brunt of this kind of legislation the most. According to the Prison Statistics of India, in 2013, Muslims, Dalits and Adivasis made up 53% of the prison population, but they are only 39% of the total population of this country. Clearly, everyone is not equal before the law. This has been the enduring message of all security laws like POTA, TADA and AFSPA. But while they disproportionately affect minorities, the wide and catch-all provisions of laws like UAPA have suspended two fundamental rights of all citizens, Article 19 and Article 21. The right to free speech and expression, to form associations and unions, and the right to life and liberty. This means that when push comes to shove, and we need them the most, our fundamental rights are meaningless. In the wake of the 2008 Mumbai blasts, the UAPA was strengthened literally overnight, after just one day of debate in the Lok Sabha. Compare that to other laws, like the Women's Reservation Bill, which have been debated for 18 years now. It begs the question, how much have we really progressed in our search for justice for all? Laws like the UAPA are often defended with the claim that we live in uncertain and unsafe times. But even if this is the case, the true test of a democracy is how it treats its people in difficult times.